Hello, everybody. Welcome to How to Help Borrowers with Private Student Loan Collection. Before we get started, we want to go over some logistics. In order to turn on live captions, please press the button with the CC symbol below. This session will be recorded and it will be uploaded to the LAAC website within 1 week of the event. You will receive your MCLE certificate within 1 week. This training is eligible for 1 hour of general MCLE credit. Please feel free to use the chat function to ask your questions. We will try to answer them going forward, but we may save them for the end of the presentation. And with that, I'm going to pass it over to our presenters.
Hi, everyone. Welcome to today's session. My name is Anna Anderson, and I'm an attorney at the National Consumer Law Center, where I work on student loan debt issues. And I'm really happy to be here today to introduce one of my colleagues and one of the leading experts in this area, Robin Smith, who will be presenting on this topic today. Robin is of counsel at the National Consumer Law Center, where she works on student loan issues and for-profit school issues, but she's also a senior attorney at the Legal Aid Foundation of Los Angeles, where again, she focuses on these student loan debt issues. So we have a really great opportunity here to learn from Robin about how she's tackling these cases. I just want to let everyone know that I will be monitoring the chat for questions. So if you put your questions in the chat throughout Robin's presentation today, we hope to address some of those as well. And I believe Robin has also said she'd be willing to stay a little bit later if folks still had outstanding questions that needed to be addressed. So feel free to put your questions in the chat or in the Q&A function as we go through the presentation, and we will try to address those ongoing. So with that, I'm going to pass it on to Robin. Robin, thank you so much, and looking forward to it.
All right. Hi, everyone. We have a lot to cover today, so I'm going to be going fairly fast, but as we said, if you have questions, go ahead and enter them in the chat, and I am willing to stay till 1:30 if folks have questions they want to raise. All right. So one thing I want to remind everyone is I'm going over a lot of information today, and we will provide you, of course, with a copy of the PowerPoint, so you have this later. But two great resources not to forget that are very helpful in these cases are, of course, the Student Loan Law Manual from NCLC, but also the Collection Actions Manual is incredibly helpful because it goes into more depth on the nuts and bolts of defending a debt collection action. So very helpful. So the roadmap for today, this is really a nuts and bolts presentation. So I'm going to start out with what is a private loan? How do you identify it? How do you gather information necessary to evaluate borrower options, both pre-litigation and during litigation? How do you evaluate a case for potential defenses and causes of action? And then how do you assert your defenses and causes of action? And again, covering both litigation and pre-litigation. So first off, very quickly, what are private loans? And we go over this because a lot of people, especially our clients, get confused about the difference between federal student loans and private student loans. So private student loans are financial projects used to fund a higher education, but they are not provided by or guaranteed by any government entity. And they are governed by the terms of the loan agreement and applicable state and federal laws. So who originates private loans? This is a pop quiz. So if folks want to enter their answers on the types of entities or people that originate private loans, that would be great. I'll just take a few seconds here. So I'll go ahead and go through these. Banks, of course, do this. Let's see what kind of questions we have. Yes, private financial institutions. These can include non-bank lenders that fintech lenders, financing companies, et cetera. So great answer. Credit unions, of course, do this as well. And schools, for-profit schools primarily, but even some nonprofits offer their own loans. So they can come from a wide variety of sources. So what kinds of financial projects do private student loans include? They include traditional loans with promissory notes. They include retail installment agreements under state law. These are often agreements that are made by the schools themselves, but they can be sold on to other entities. They include enrollment agreements that have financing terms when a person doesn't pay the full tuition amount. And they can also include new types of agreements, such as income share agreements. And those are agreements where a student is obligated to pay a fixed percentage of their income after graduation for a fixed period of time. And this is an area that continues to morph and change as we see new kinds of products coming on the market all the time. And I suspect we will see an increase in these as the new federal student loan limits sort of start to impact the students. So who collects on private loans? This is another pop quiz, but I'm just going to go ahead and go through the answers for the interests of time. So third-party debt collectors collect on these loans. These are entities that are basically collection agencies that are hired by the loan holders to collect on the loans after the person has typically defaulted. Loan servicers, like Mohila, is a big common one that not only collects on federal student loans, but also on private debts on behalf of Navient. The original lender, sometimes the original lender does not transfer the loan and keeps it and collects on the loan. Sometimes there are insurance companies or nonprofits that guarantee private loans. And sometimes in those cases, they will be collecting if the loan has gone into default. And finally, securitized loan trusts. So just like the mortgages of today and for a very long time, a lot of the private student loans are bundled in large tranches and sold as securities. So especially this is common with the promissory note types of student loans. So you will see a lot of securitized loan trusts serving as plaintiffs or collectors in these cases. And finally, debt buyers. So we know that Sallie Mae, Navient, and some of the other big banks that make private loans sell defaulted debts to debt buyers. So you will often see this as well. And then, of course, there may be other transferees because a lot of these buyers or these loan holders can sell on the debt to other entities. So given all of this information, how do you evaluate a case and where do you start? So first of all, you have to make sure, of course, that the debt is a private student loan. And one way to do that is to check both you can check to see if there's a Truth in Lending Act notice. You can check the federal student loan data system to see if it's listed there. If it's not, it's definitely not a federal student loan in most cases. And of course, you can check the credit reports. So those are all sources of information. But it's assuming you've determined that it is a private student loan. This is the evaluation checklist, both pre-litigation and if you've been served with a lawsuit, your client's been served with a lawsuit. I always check to see if the client's judgment proof. As a legal aid attorney, we have way more demand for our services than we can provide. And so we only typically represent people who are not judgment proof. If they are, we will usually pass on the case because ultimately, what this means is that if a judgment is obtained by a private creditor against the client, there's no assets. The client doesn't have any assets or income that the collector could take. And so in those cases, we don't typically represent people, but of course, that's up to you. The second thing you look at is, do you have the necessary documents to assess the status of the loan and the borrower's options? The third thing you look at once you get the loans that you will need to evaluate the case is, do they have any defenses? Do they have any affirmative claims? You have to look at whether a judgment's already been entered against the borrower, because there are times when a borrower will come to you because they've just been served with some kind of request. For example, maybe their bank account's been frozen, or they have been ordered to a debtor's exam, or some post-judgment proceeding is happening. And then, of course, other options. So first, I'm going to talk about the pre-litigation gathering of information. So where do you start? So you really are going to need to get a payment history, first of all, so you can really look at potential defenses related to statute of limitations and other issues. And then you need the loan information, including the loan documents. Usually you can often, if the borrower has a login for the loan holder's website, they can often download those and provide those to you along with the promissory notes and Truth in Lending Act notices. But if you cannot get those, there are other ways to get those. Sometimes your borrower won't know who's calling them or collecting. And so you want to ask them, of course, for any letters they're receiving, and you can check their annual credit report. You can request documentation from the loan holder, the loan servicer, or the debt collector under state or federal laws, which I'm going to cover in just a minute. And when you do so, you want to make sure you include an authorization signed by the client so that they will release to you the personal private information. So here's how you obtain documents. I'm going to cover California law because that's what I'm most familiar with, but I do want to point out other states, many other states have similar helpful laws for you to evaluate whether or not another state has those laws. The manuals you want to look at are the Student Loan Law Manual, the Collection Action Manual, and the Fair Debt Collection Practices. So those are 3 really helpful manuals that will get you started on your research if you're not in California or if you are in California. In California, you have a right, borrowers have a right to dispute their debt and to demand documents under the Rosenthal Fair Debt Collection Practices Act, where they can do a debt dispute and verification request. They can do a request under the Private Student Loan Collections Reform Act. When a loan has been accelerated or there has been no payment for 12 consecutive months, and they can do a qualified written request under the Student Loan Borrower Bill of Rights. So California has really strong laws that allow the borrowers and you to obtain their documents. Other sources of documentation that can be incredibly helpful include the Family Education and Rights Privacy Act. And under that law, you can demand the student records from the school if the school gets Title IV funding, federal student loans. You can request the entire student record, and that way you can also see what is in the student's file with respect to financial aid. And we have sample letters for all of these kinds of requests. I have those if anyone's interested, and I believe we also have them on the companion materials to the MCLE Student Loan Law Manual. So feel free to let me know if you're interested and we can provide those to you. You can also, if you have a third-party debt collector that has acquired, that is collecting a defaulted debt, you can also request documents, both dispute and request loan verification under the Federal Fair Debt Collection Practices Act. Not all states have fair debt collection laws that allow you to request documents from the creditor, whether or not it's in default. In those cases, you might have to turn to the Fair Debt Collection Practices Act if the loan's been defaulted and you have a third-party debt collector. So what documents do you want to request? You want to make sure, of course, that you get the loan contract and the promissory note, whatever document it is that creates the borrower's obligation to pay the loan, that's the document you want. You want the disclosures. So those are primarily going to be Truth in Lending Act disclosures. You want all communications to and from the borrower by the loan holder or any entity collecting for the loan holder. These include collection letters, monthly statements, emails, anything like that. Of course, the payment history, and always request the documentation of the loan assignment from the original creditor all the way to the current loan holder, because that's going to be a key potential defense for you. Under the Rosenthal Fair Debt Collection Practices Act, and this may be similar in other states, what must collectors, servicers provide? This is not always a clear issue in terms of the documentation, but if you dispute the debt on the correct basis, you can ask for the documentation that underlies that dispute and will help you to figure out if you have a valid a defense based on that. So I specifically request every document I want in the written request, and then I also make sure, again, that the disputes are relevant to the documents I've requested. So here's some sample disputes, the kinds that I will raise, that the borrower does not know anything to the loan holder, the loan holder is not named in the loan agreement. The amount requested is incorrectly calculated pursuant to the payment history or the terms of the loan. The school engaged in illegal practices. Those are all very common. And then if you ask for those, these are the types of documents. You have a very wide range of documents you can request. So going now past the documentation, you may also request on behalf of the borrower that the servicer or debt collector stop contacting the borrower by phone or text. That's provided for in California law and may also be available in some other states. And you may also demand that all communications go through you. If you are representing the borrower, there is specific language you have to use when you make that request. It's set out in Civil Code Section 1788.14C. There are similar provisions in the Rosenthal Fair Debt, in the Federal Fair Debt Collection Practices Act. Sometimes it takes a while to get these documents. Just to warn you, I usually have to go back and forth a few times before they finally give me everything I've requested, especially the transfer documents. If there's multiple transfers between different loan trusts, I usually have to go back and demand that from them. So just so you know, it's not always easy to get these things. Once you get all the documents, you want to assess them for all potential defenses and causes of action. And then pre-litigation, if you determine there are defenses or causes of action, you can write a demand letter asserting those defenses and violations. And one thing I really want to point out too that we forget about is that Chapter 7 bankruptcy may be the best option for some borrowers. It's definitely something to look at and not to forget that it can be available. And I will briefly cover that towards the end of this, but I just want to make sure people keep that in mind, that just because a person doesn't have any defenses or there are any violations doesn't mean you stop there. If there are violations that you're seeing, I also encourage you to submit a complaint to the DFPI for violations. The DFPI in California oversees loan servicers and private student loan lenders, including schools. So if you're seeing any violations of California laws, you can go ahead and submit a complaint. There are a few states that similarly have oversight agencies, including, I believe, New York and Connecticut. I don't know off the top of my head, but we do cover this in the student loan law manual. But they can be a great place to submit a complaint. And sometimes you can resolve it that way, but not always. But it's good to let them know what's going on in the hopes that maybe in the future they will prosecute some of these organizations for their misconduct. And then also consider filing a complaint with your state AG's office. So now I'm going to cover how you assert defenses and claims regarding private student loan collection. So one thing that's really important is once a borrower is served with a debt collection complaint, you want to be very careful about advising that borrower to submit a pro se answer or sending them to a self-help clinic. And that's because there are several affirmative defenses that they have to raise or they will lose them. And that includes the statute of limitations. So just be very cautious about just letting them do their own answer because it can cause problems. In addition, there may be some mandatory counterclaims that the borrower will waive if they don't assert them as the first response to the complaint. So again, be very cautious about doing pro se, having them do anything pro se or sending them to self-help. So how do you evaluate? So here's a list of the most common sort of defenses and cross claims that I often see in these cases. Of course, statute of limitations is a big one, but the rest of them are a little less hard to figure out. Sort of lack of proof of ownership of the loan. So again, if you have a plaintiff that is not the named original creditor in the contract, then they have to prove that they own the loan and have a right to collect on it. Otherwise, anyone could obtain a copy of a contract and say, hey, I'm the owner now and you need to pay me. They actually need to prove chain of title. And I'll cover this a little bit more later. School misconduct. So if if the borrower went to a school that engaged in state law violations and the borrower has a cause of action against the school, in most cases, they can similarly assert those claims against the lender, the loan holder, either assert as an affirmative claim or as a defense. Of course, you want to look at the disclosure and loan documentation laws, both the Truth in Lending Act and when applicable state laws are available. In California, that's the Unruh Act, which covers retail installment contracts. You want to look at those. In California, also, we have the Private Student Loan Collections Reform Act, which is really important and provides very helpful protections. Again, some other states do have similar statutes. The Fair Debt Buying Practices Act, when you have a debt buyer, and then, of course, the Rosenthal Fair Debt Collection Practices Act. So one of the issues that comes up a lot is there's usually often in these contracts a choice of law provision, choosing some other state law besides California. And it's hard to figure out, does California law apply? Does the California statute of limitation apply, or does the other states? So that's the question here. So which state law is chosen? Okay, some California courts have held that the court must apply the statute of limitation of the chosen state when the original lender is incorporated there. So this is Hughes Electric Corp. It isn't a Supreme Court case. These are appellate level cases or not Supreme Court. So it's, you cannot just assume that California law will apply. It's really important to take a look at the law in your district and sort of what this other state law does. And then also be careful about how default is defined by the applicable state law. How default is defined depends on the terms of the loan. So you have to, if the state law provides that the statute starts to run upon default, then you have to go look at the contract to see how default is defined. Often it's defined as default happens when the loan holder says it does and they accelerate the loan. Basically, they declare the loan in default and say, you've defaulted, now you have to pay off the entire contract in one lump sum. That's typically how default is defined. So it doesn't begin to run until that time, often in many cases. So the California statute of limitations for breach of written contract is 4 years from the date of default. It's typically computed as 4 years from the date of default, or there is some case law in California that it's 4 years from the date of each missed payment. So that means each missed payment has its own statute of limitations, which is 4 years, when an installment payment plan is detailed on the date the loan is originated. So just to be aware that you have, if you have one of these situations where there is a set installment payment plan on the date the loan is originated, that's going to be what applies. You have to look at each payment until and when the loan is accelerated, and then that's when you stop looking at the payments moving forward. If the SOL has expired, the borrower has no obligation to repay the loan and should not make any payments. In fact, making payments might revive the loan and restart the statute, so best not to make payments. In addition, California civil codes, these apply to debt buyers and to private student lenders. Prohibit collection in a written statement or via a lawsuit if the statute of limitations has run and there is a cause of action for violation of this provision. There may be Rosenthal violations as well if the loan holder is misrepresenting the legal obligation to pay the debt, or if they're failing to make certain disclosures that are required when the statute of limitations has run. Pre-litigation, if the statute of limitations it has expired, I write a demand letter telling them to stop collecting and alerting them to the fact that by continuing to collect, they are violating these provisions, and my client will take action if they continue. Your client does have a cause of action if they take action within 1 year after the violation, and you can also assert Rosenthal violation. So again, you can assert your client does have a cause of action, both under the Debt Buyer Practices Act, if there are debt buyers involved, under the Private Student Loan Lending Act for the creditor, and anyone collecting, and then possibly under Rosenthal. But again, these all have a 1-year statute of limitations, so it's pretty short. I'll take a pause real quick and see if anyone has questions.
And I don't see any questions yet, but please, if anyone has questions, feel free to put them in the chat or the Q&A, and we will make sure that we respond to those. So thanks, Robin.
Sorry, I know I'm covering a lot, so going really fast. Okay, so next area we're going into. So, sorry, Okay, so I'm going to cover some of the very common defenses that you want to raise in these cases. One of the biggest one is taking a look at who owns the loan. If it's not the original creditor, you're going to potentially have some very good defenses based on the documentation of the transfers in the case. So if it's not the original creditor, as I previously talked about, it could be a securitized loan trust. So that's like a national collegiate student loan trust loan, or Navient, or even a Sallie Mae loan. They're all often in trusts. It could be a loan guarantor. So an insurance company. I often see insurance companies that have guaranteed the loans as plaintiffs in these cases. And it could be just a subsequent transferee or entity that has purchased the portfolio loans after charge-off, including debt buyers. So these are the most common plaintiffs you're going to see in these lawsuits. Here are some examples. I mentioned the securitized loan trusts. Guarantors include Arrowwood Indemnity and the Education Resource Inc. And debt buyers, the most common debt buyers we're seeing right now include Credit Corp Solutions, Student Loan Solutions, Jefferson Capital, Rock Creek Capital, Southwood Financial, and I'm sure there's others that I'm missing, but these are the ones we've been most commonly litigating against. And then we also are still seeing some National Collegiate Student Loan Trust loans. These are typically transferred from an original lender to an intermediary and then to a loan trust. And based on both an action by the CFPB against the National Collegiate Student Loan Trust and other sources of information, we know that they do not have the schedules identifying the individual loans in each of the loan transfers, and the transfers are thousands of loans. So how do we even know there's a loan, that our client's loan was in one of these transfers, if they don't have an individual schedule sort of identifying it? Others have similar issues because Sallie Mae loans and Navient loans, I've had clients where those loans are, transferred 20, 30 times before the time they come to me for help. So those are all issues for those securitized loans. And you see the debt buyers have similar issues because before they get the loans, you'll have all the loans will be transferred between multiple trusts, and finally they're transferred to the debt buyer. And then we often see problems also with the debt buyer's documentation, not identifying the individual loan that's being transferred. I want to highlight Credit Corp Solutions. If you see one of these cases, we have seen evidence that they are using the same schedule for all of their cases on the same page. It's page 81. It's the second line. Everything else is blacked out, and the client's loan appears there. It's very fishy, and we've seen it even in credit card cases. So we think that they are fraudulently possibly using schedules that they're preparing for the case. So keep an eye out for the Credit Corp Solutions case. We have filed complaints with government agencies about them, but we haven't really seen any action on behalf by the government on those cases. So as I mentioned before, if the loan holder is not named in the loan agreement, how does the borrower know that it's the right person to pay? California provides that the plaintiff must show it is the real party in interest, and the plaintiff must show a continuous, unbroken chain of assignment from the original creditor to the current holder. And notably, each assignment document must reference the specific borrower account. And this is why I get into, did the bill of sale have a schedule attached that identified the individual loan? And if not, then there's a real problem there for the plaintiff. So the Private Student Loan Collections Reform Act requires, again, the chain of title documentation. Note that plaintiffs often only attach to the complaint the last bill of sale with no schedule. The schedule usually only identifies a large list of pools of loans without any individual, a schedule listing the individual loans being transferred. And often plaintiffs attach a document that was created after the loan transfers and was not an original assignment document. A lot of times these are prepared for litigation, but not always. Example, the National Collegiate Student Loan Trust always attach what's called a roster. Every time I've tried to do a deposition to find out what the heck it is and who prepared it, they settle the case. So, but I don't believe that's a document that was part of the bill of sale. Here's an example of where you can see why this is an issue. And this is a way to present it to the court if you're getting to the point where you're able to substantively argue these issues in a motion for summary judgment or even at trial in a pretrial brief. I like to do these kinds of charts so that the court can see each transfer and what's missing from each. Here in a National Collegiate Student Loan case, we've got the deposit and sale agreements, which are available from the FTC website. They're public documents. They refer to the sale of large, huge tranches of loans, but there is no schedule attached. They refer to the Schedule 1. Here's the Schedule A. So these are all the different tranches of loans that are being scheduled, a huge amount, but there's no Schedule 1. And instead I get this thing this is usually obtained through discovery, this thing called a roster, which I don't believe is the schedule. It's something created after the transfer happens. Here's another one. This is Credit Corp Solutions. This was the entity, the debt buyer I was talking to you about that we suspect is engaging in fraudulent, the use of fraudulent documents. Again, it refers to an account schedule. Here's the account schedule they often provide. So again, you can see there's a transfer of 148 accounts that come out of these different trusts, and you don't know which one belongs to your client. Like, how do you know, or how did they prove that your client's loan was actually transferred from one of these trusts? And then this is the document they usually provide as the schedule, and it's the 81-page document, always on the same page, always in the same location for different people. So it's very fishy. So if it's not the original creditor, pre-litigation, you can write a demand letter asserting the prohibitions in California's laws about collection if they don't have the transfer documents. And of course, you can assert them as both affirmative defenses and cross claims if in litigation. And again, there is a 1-year statute of limitation on these, although, if they're filing a complaint, they're violating the law basically without these documents. So these are these must be attached to the complaint, all pages of the loan agreement. So I do see cases where they don't attach they just attach one page, the front page of the loan agreement. And sometimes they don't even have the rest of the loan agreement, by the way. Sometimes they don't attach the TILA disclosure, and the Truth in Lending Act is incorporated into the promissory note. It's the only way you can identify the actual interest rates, among other things, and sometimes the creditor. So without that, again, they're missing the entire loan agreement. And there are similar provisions in the Fair Debt Buying Practices Act. It also requires that the complaint includes specific allegations. It prohibits the bringing of a lawsuit if the statute of limitations has expired. It prohibits entry of judgment unless all the documents to prove that the SOL has not expired and the chain of title are properly authenticated and admissible as a business record. So a lot of times, again, the plaintiffs will have a hard time getting this in evidence because they cannot produce a witness that has personal knowledge regarding different factors, including the creation of the bill of sale and the schedule attached to it. And they also have a problem with a lot of other evidence and providing a witness that has the sufficient personal knowledge to get it into evidence. the Fair Debt Buying Practices Act has some similar prohibitions and provisions. So if you have a debt buyer, make sure you take a look at this. So some other sticky issues to think about in litigating these cases, the plaintiff does have the burden to prove damages and how they were calculated under the terms of the contracts. They have such a hard time doing this. They just give you what they got from whoever, this chart they got from the person they bought the debt from, and they can't explain it. So that's really something to push on. Again, they have personal knowledge issues, and they do have the burden. Electronic signature issues. A lot of these loans are electronically signed. They have to show that the person who signed the document was in fact your client. I haven't really gotten far on this, but it's definitely worth pushing them on this issue. They have to prove that the boilerplate contract terms are the terms the borrower agreed to. Usually what you'll see is a bunch of boilerplate terms with a number on the bottom attached as the promissory note. And we know that a lot of these lenders had different prom notes during different time periods. And again, as I said, the plaintiff's witness has to have personal knowledge to testify to all of this information. And this is the evidence strategy. Okay. I'll stop for any other questions. See if there's any questions about any of this.
Still no questions. But again, yeah, if folks have those, let us know. I'm imagining, Robin, we might get some at the end.
Okay, that's great. And now I want to cover another topic that's really important and is often overlooked is defenses based on a cause of action for a school's misconduct. Many of these loans include what's called an FDC holder rule clause, which basically provides that any causes of action the borrower has against the seller, in which case it would be the school, they can assert as a defense or affirmatively against the loan holder, whoever that is. Any subsequent assignee is subject to this provision. In most cases, note that the loan contract has to contain this information. If it doesn't have that provision, there may be a problem asserting it. We do cover this in our federal abuse law. I don't remember. Federal deception law manual covers this really in depth. So if you have a situation where it's not in the contract, take a look at that manual. However, if the original lender is the school or the seller and the language is missing, it will be implied in the contract. So that's the one case where even if the FTC holder rule clause language is not included, it can still be implied into the contract if the original lender was the school itself. So here's common questions you want to ask when you want to assess school-based offenses. Most commonly, you're going to see these with for-profit schools. However, I would still ask these, especially if you have an online case, a student who went to an online public institution program or a nonprofit, because we are seeing fraud. One example is the USC social worker master's program case, because a lot of these schools have contracts with for-profit companies either to do marketing or to actually run these programs. So while I definitely ask these for-profit, think about asking them as well for other types of schools, which unfortunately are starting also to engage in fraud. Was the student unable to complete their education due to a school closure? Did they go to a for-profit college? Or I went over that one. Did the school or recruiter lie to the student about anything? Was the student able to find the type of job they trained for? What was the quality of the education? And on and on. And we cover all of this sort of in our manual, but you're looking for any kind of misrepresentations made during the recruitment and while the student was enrolled. For closed school students, note that a sudden school closure is, of course, a breach of contract. So that's a claim right there. In California, of course, if a student is unable to complete their education due to a school closure, they are eligible to apply for strict relief, including for their private student loans. So if you have a student coming in fairly short, within 4 years after the school closure, unfortunately, there is a statute of limitation. this is something that they can use to pay off their private student loans. Other states have strips as well, and we have a report covering that, so you can look that report up to see what the law is in your state if you're not in California. So common school-based offenses include, of course, Business and Professions Code 17200. That includes both unfair and deceptive practices, as well as violations of other laws. For-profit consumer statute, we have the Bureau for Private Post-Secondary Education's Act, and definitely take a look at that. It applies primarily to for-profit and nonprofit institutions, but your school, if it is licensed by the Bureau, is subject to those laws. Civil Code 1750, that's the CLRA, the Consumer Legal Remedies Act in California, regarding the quality and representations made about the product that's being sold. And then, of course, you have your common law claims. To file an affirmative claim, cross-claim, or arbitration, so one thing to note is if you're going to assert a cause of action, say you want to assert the actual school violation as an affirmative claim against the loan holder, it has to be within the statute of limitations. So for example, if it's a 17-200 claim, it has to be brought within 4 years generally of the violation. A lot of times you're going to be way past that period because loan holders, they sue way past, usually start to collect and sue way past the dates, so that the statute of limitation has expired. So in California, though, you can still bring it as an affirmative defense. So make sure you include that. This is an example of an affirmative defense you have to claim or your client will lose if they don't do that. Pre-litigation, you can assert it by a demand letter, and litigation, of course, past SOL's affirmative defense. So if you're going to do it pre-litigation, make sure you include a demand letter with evidence. The evidence primarily is going to be a very in-depth declaration from your client, along with any supporting documentation you can provide, such as Department of Education findings, which is common for the big schools like the Art Institutes, ITT Tech, the ones where there have been widespread relief by the Department of Education based on school misconduct. There may be other sources of evidence as well that you can include. I do want to note Navient has a special process. They've actually created a borrower misconduct or school misconduct claim that your borrower can fill out and submit. But again, you really need to include additional evidence before you do that. And then Navient responds in different ways. For my clients, they've been ignoring them and just not collecting. And so we're just basically waiting for the statute of limitations to run. But other people, they continue collection. Sparky Abraham, who's another attorney, student loan attorney here in California, just got a successful, withstood a motion to dismiss in district court on one of these cases. I should provide a link because it's a great decision. And it really explains the sort of really atrocious debt collection actions that Navient engaged in after the borrower asserted this borrower defense, submitted this application. And this is an Art Institute borrower who had gotten a discharge from the Department of Education. So this is the school misconduct application. It used to be on their website. If you don't have it and you want it, you can email me. I believe the Project for Predatory Student Lending also may have it on its website, but if not, you can also email them. And you can also ask for one from Navient itself. So you can ask for one from MOHELA, which is the Navient Private Loan Servicer. So as I mentioned before, the PPSL, the Project on Predatory Student Lending, they have a terrific for borrower defense discharge applications. It's for federal applications, but you can follow the same directions for the private student loan ones in terms of what evidence you want to submit. And they did their own campaign on the Navient student loans. Please let us know if you do submit these. We'd love to hear the outcomes. We're trying to track what Navient's doing with these cases. And as I said before, be aware MOHELA is collecting on Navient loans. but it's a separate unit or division from the federal loan, Navient, Mohila. So you have to send it to a different mailing address. I messed up on this in one of my cases and figured it out eventually, but just be aware there's two different addresses for Mohila, depending on if it's a federal or private loan you're corresponding about. Okay, I saw there might have been a question. Oh, no.
I don't think it's a question. I just put in the links that you had mentioned in the chat.
Oh,
So I put in the case as a PDF, and I also put in a link to NCLC's listserv where Sparky posted the great outcome there.
Great. Thank you so much. Awesome.
No problem.
All right. And Sparky filed it was an affirmative case against Navient for loan servicing abuses under California law. So really a helpful, great case to look at if you're thinking of getting into this area. So some other defenses and cross claims that I didn't cover in depth, but you need to be mindful of, service member defenses and cross claims relating to the interest rate that creditors can charge when a service member is on active duty. Of course, the Truth in Lending Act Truth in Lending Act, as well as retail installment credit agreements. These are about the disclosures that have to be made, and in the case of the Unruh Act, also what terms have to be included in the contract. Identity theft, of course, happens in these cases. File a police report, or you can report to the FTC. You should dispute the debt on the credit reports, submit a dispute to the loan holder, and if none of this works, file a complaint with government agencies. And of course, raise it as a defense if your client's sued. So some other sticky issues I just wanted to highlight. One of the issues we have in California when we assert cross claims based on the Debt Buyer Practices Act or the Private Student Loan Collection Practices Act is we get an anti-SLAPP motion, basically seeking to strike the complaint because if you challenge statements made in litigation, they can then file an anti-SLAPP motion. So we've been very carefully crafting our complaints so we don't typically allege that they made misstatements in their complaint. We've learned. So you want to be really careful about what you allege in your cross claims to avoid an anti-SLAPP motion to strike. If you do still face one, that's fine. It's not the end of the world. We have sample opposition briefs if you need one. And we're also collecting just information on this because we are considering looking at potential legislation to fix the abuse of this law particularly by debt buyers and debt collectors. Now, for discovery, we also have sample discovery if folks are interested. It's really important if you get involved in the case soon enough to do a person most knowledgeable deposition. When I do these, typically, the day of or day before, they agree to dismiss the case with prejudice. And so it's a really good practice to engage in it, besides the fact that you can get great information if you are going to go to trial. So or do a motion for summary judgment. So always do those. And again, I have sample discovery. These are all the different kinds of sample pleadings and documents I have, or we have. If you're interested, just let us know. Finally, options for borrowers with judgments. You want to evaluate how did the borrower find out about the judgment? You want to look at the proof of service of the complaint. Was the borrower properly served under California or the applicable law? So if they weren't properly served, and you can then move to set aside the motion for summary judgment if you comply with the requirements of the various CCP sections. The biggest issue usually is when did they find out about the judgment, and then have they acted within the time frame to seek to set it aside. In addition, they can note something really important is they have a cause of action as well. They have a cause of action if a default judgment was entered and the loan holder didn't attach to the complaint all of the documents required under California law. And under that law, one of the remedies is to have the default set aside. Other questions is the borrower judgment proof again? And also looking at, is Chapter 7 bankruptcy an option? If you have a client that doesn't, you can't really get out of the judgment and they're not judgment proof and Chapter 7 is not going to work, then you can try to negotiate a payment plan or a settlement with the loan holder. Some other options for folks, and this is for folks pre-litigation, I would say, is some loan holders will offer disability discharges. You have to research this and look at your promissory note to see if there's a provision allowing for disability or death discharges, or you can look at their website, or you can ask them. If they do have a process, it usually involves submitting the doctor's certification and medical records to an insurance company who then makes the decision. And they all have their different standards. So it's just something you have to really research and figure out depending on who the loan holder is. And of course, Chapter 7 bankruptcy. In most circumstances, if a private loan is a qualified education loan, then the borrower has to file an adversary proceeding within the Chapter 7 case and has to prove that repaying the loan will impose an undue hardship. I don't know what hidden, anyway, I don't know why that's there. This is the qualified education loan is defined by IRS Code Section 2221. It's really important not to assume that the private loan will qualify because there are circumstances where the private loan may not be subject to the undue hardship provision. For example, if the student attended an unaccredited school, if the student was not eligible for a federal loan, for example, it was an undocumented borrower, the total financial aid or money paid to the school exceeded the school's stated cost of attendance. So all schools that get Title IV funding have to establish what's called a cost of attendance, and that's the total cost that they tell the federal government that a program will be. And then finally, a borrower is not closely related to a student. So this is a good one. If you have a friend of a borrower that signed as a co-signer, then they are not subject to the undue hardship standard. So we do cover this. It's actually a much more extensive list, and we listed them all at this publication. So take a look at that. And finally, some other options are forbearances. You can try to modify the loan or get into a settlement agreement with them, and of course refinancing. But we understand the refinancing market, you have to have a borrower with a very high credit score typically to get that. Submit complaints to all of these agencies and any that are in your state. All right, that's it. I made it through it. It's a lot of information. So do folks have any questions? I see someone raise their hand. I'm not sure how to let them talk.
I'm not seeing any hands raised. If you wanted to come off, raise your hand.
So I think
Okay, Amy,
someone,
you should be able to talk.
okay.
Okay, great. Hi, Robin.
Hey.
So I was just wondering, have you encountered Southwood Financial at all in terms of,
Yes.
okay, anything particular that we should be aware of with them?
Yes. So Southwood's interesting. We filed a motion to dismiss in their case because an LLC that claims to be the manager of the trust is the one that is serving as the plaintiff, which
Yes.
is really strange because
Hmm.
typically the plaintiffs in California are typically either the trust themselves or the trustee. We won our motion to dismiss in our case, and they are filing an amended complaint with what are probably sufficient allegations that the manager got authority from the trustee to litigate the case. But
Hmm.
we're going to be doing discovery on that. The other issues with Southwood are all of the issues that I raised. You're going to want to look at the transfer from the original creditor all the way up to them
Right.
because they are a debt collector.
Yeah.
and they buy the debt after the borrowers have defaulted,
Hmm.
and their counsel is not great.
Okay. Should I email you for the motion or?
Yeah, yeah. Go ahead and email me.
Okay, great. And then another question that I know you all deal with to some degree. I think with these cases, they feel like ones where discovery is more important, but at least with Hera's model, we don't generally represent most of our folks that we're assisting that remain in pro per. And for some of them, I mean, of course, we could draft discovery for them regardless, right? But sometimes just, even participating in discovery can be really overwhelming. I don't know if you have any tips or you just basically, for folks who remain in pro per, just essentially like ghost litigate the case.
I mean, you can
Um,
do that. We just take the cases on because once you've done one or two,
yeah.
they don't take a lot of time, quite honestly, unless you have
Hmm.
to trial, which does happen
Right, right.
sometimes. But usually because I've already got so much, I've already got all the discovery drafted. Our client doesn't have anything to give.
Right.
It's pretty straightforward.
Yeah.
And so we generally represent folks if they're not judgment proof. And
Right.
almost pretty much all our cases get dismissed with prejudice eventually.
Okay, interesting. And then last question, this is more of like a
But
statutory question.
but to
Yeah.
answer your question, I have ghosted. So
Okay.
sometimes if I'm not sure if they have or like I don't even have the promissory note or any information, and I'm not sure if I want to represent them because I don't have enough information, sometimes I will do help them with the answer pro se. I
Yeah.
will draft pro se, and I'll do a retainer agreement for each step of the process, and then I'll do pro se discovery, and then I get once I get information, I can decide if I want to make represent them in the case.
Okay, got it. Yeah, that makes sense. And then something else I was wondering about, I'm sure you've seen this before as well. When there is a cosigner, let's say you're assisting the cosigner, and they are a relative, not like a friend or like a, girlfriend or
Yeah,
whatever. Um, I know typically we oftentimes raise that the loan agreement wasn't in the language that's spoken or read by the borrower.
yeah.
But do you know if that's as effective with a cosigner versus a borrower themselves?
I have no idea. I've never done
Okay.
that.
Okay. Okay.
I mean, yeah, you just have to research whether our civil code covers that situation.
Okay, yeah, just was curious if you've done it. Yeah, just because I'm sure there's a lot of situations where like the child,
Yeah,
borrower speaks English and then the parent may not, but
yeah,
they're co-signing. Okay, great. All right, thanks.
sure. Any other questions? I think I do think you all have my email. Make sure you have it so you can email me if you want anything or have any questions. Um,
I
feel
also
free to do so.
I dropped my email in as well in case anyone has questions specifically about NCLC materials or getting onto listservs, technical questions. I'm happy to field those so Robin can focus on your tough substantive questions. Thank you, Amy,
Well,
for
I'm thinking
raising
of
those.
listservs. We do have a student loan listserv. So if you're interested, you can actually go to the NCLC website. And I think you can just sign on there.
Yes, and I did put the link in the chat
Okay.
to sign up for any of the various NCLC listservs, including the student loan general listserv. We also have a legal aid student loan listserv if you want to sign up for that separately, because we do provide monthly meetings for legal aid attorneys working on student loan cases in addition to other resources that are available.
Well, thank you, everyone. I hope this was helpful.
Thank you.
Thank you, Robin. It was super helpful.
Great.